Ladies and gentlemen, welcome back to the Indie Zone. This is Kathy, where today we are evaluating a notice regarding hearing date on motion to appeal, amend, and or clarify amended non-dissemination order that was entered on February 27th, 2023 in the case styled as Idaho versus Kohberger. This notice was actually signed and entered by Judge Marshall, who was at that time the presiding judge in the case. And in this notice, several things are happening. First, the court is reminding the world that on February 3rd, that Mr. Gray did file a motion seeking relief from the non-dissemination order, and that thereafter, the prosecution on the 8th of February and the defense on the 9th of February filed their respective responses, where they both opposed Mr. Gray's motion and asked the court to essentially deny the relief that he was seeking in that motion. The court then goes into another matter entirely that relates directly to that non-dissemination order, that gag order, in my opinion, which is what it is because it directs certain parties from stating certain things outside of court and from doing certain things outside of court. She tells us here that a petition for writ of mandamus or writ of prohibition was filed with the Idaho Supreme Court, docket number 504822023 on February 6th, 2023, and that it is entitled The Associated Press et al. Versus Second Judicial District of the State of Idaho, County of Latah, Honorable Megan E. Marshall, Magistrate Judge. And she says here again that it is related to the non-dissemination order at issue in Mr. Gray's filing. Now, what is a writ of mandamus or prohibition? Well, what the petitioner here, which is the Associated Press et al. Tells us other people are involved, other entities have joined in, and that there are multiple petitioners. They're seeking the entry of some type of an order from the Idaho Supreme Court directing Judge Marshall to do something or not do something. And a writ of prohibition or mandamus is essentially going to an upper authority and saying, look, the lower tribunal has done something improper here. She's made an incorrect ruling. There's an abuse of power. There's an improper exercise of power and authority, those types of things. So they're basically appealing this non-dissemination order, the press is, directly with the Idaho Supreme Court. So Judge Marshall, noting that this proceeding is ongoing, there hasn't been any decision, she gives us a schedule of what the court has done, the Supreme Court has done, has directed that a response is due within a certain date and that a reply by the petitioners to the response is due subsequently. And she also notes that no oral argument has been scheduled yet in the Idaho Supreme Court. Given these developments, the court then has found, and I agree in my opinion, that she could not make a ruling on that order because it is before the Idaho Supreme Court at this time. So what this notice then states is that the court has determined that nothing will happen. The hearing on the motion and therefore a ruling on Mr. Gray's motion will not happen until the matter in the Supreme Court is completely resolved. At that time, then a hearing will be scheduled where Mr. Gray will have an opportunity to come into the court and the other parties, the state and Mr. Kohberger will have an opportunity to respond. So nothing is going to happen in the lower tribunal until the Idaho Supreme Court makes its ruling and closes that case. That will conclude this episode for today. Thank you very much for joining us.